Good afternoon. It's May 30th. I'm Alan Osborne. You can't make this shit up. Behind me, you're going to see Lidwell and two of his favorite proteges. These are men that he defended to the end. And you can go back and watch the show that's got this as the cover page, and that'll be self explanatory. But today, I'm going to shift gears from the crookedness in Okaloosa County over here back to the BCC crookedness in Walton County. So what we've got here is the last BCC meeting in Walton County was such a shit show. I'm gonna break it down into the development shit show, the code shit show, and then the third shit show on some other issues coming up. I'm not even gonna leak it. You're gonna have to watch my show. So anyway, we start out with a zoning change down in South Walton. And if you ever want to see it, mostly I'm going to let the commissioner's actions speak for themselves, because you're going to see Curry ask some hard questions, and you're going to see that an attorney named Shipman, in my opinion, is running the planning department. In fact, I think Brooke is an attorney or some kind of role like that in the planning department. And it seems to be that Brooke and Shipman are deciding what the rules are. But even Brooks' boss, if you listen close, Stephen Showen disagrees with him. So I'm going to tell you how it starts out, and I'm going to tell you what to listen to, and I'm going to put things in context. That way you don't have to watch the whole BCC. You can just watch the part. And I hope the people who lived around this. So what this is a typical bait and switch. When there's issues, they just continue. They bring all the people there that got to get off of work that don't benefit, that stand to lose, and they continue it and continue it and continue it till they whittle down the people who can make it. This is an issue where the development clearly would have been shot down because the public knew what it wasn't complying with, and they've advertised it that it's done. Everybody in planning has gone over technical review, and the public has caught the planning department speeding again. Even Stephen doesn't agree with Brooke and Shipman or Clay that they can go ahead and hear it, or they can withdraw the application. So the applicant has a choice that he has scheduled this event, publicly noticed it, the affected people are there, and the day that they're showing up, it's like they don't matter. This is how pro-development and anti-community citizens and pro-tourist they are. It doesn't matter. We're going to develop it. In fact, Shipman never says in case you get development. He wants this lure land use agreement in these flooded areas. Well, there's no use to draft that. If it's a requirement, fine, but don't draft it till it gets approved. But Shipman doesn't want to be slowed down because he knows he's going to get the approval. Even though he's here today, and Clay says, if you hear it today, I recommend disapproval. Now, two or three things are really bad about this. First, they get into a long discussion because they're not having a hearing. Nobody's been sworn in. This isn't quasi-judicial. So they're up there with defendants and applicants having open discussions about a legal fight. Who's going to sue who? Well, that's against BCC policy. They don't discuss things. So right away, they shouldn't have discussed this, and they should have just forced him to have the hearing, and Clay should have recommended, as he said, that you not approve it. But that's the applicant's fault. He could withdraw it. And if the people commented today, Clay said they couldn't comment ever again. Why not, Clay? Because the applicant has the option of presenting the information, and the applicants were on, or the affected people were on notice that they had to come speak. Well, if he doesn't give them any information today, they can speak on whatever they want today, in my opinion. And then once he says what he's going to do, they can't speak on the things that they've already talked about. But why can't they speak on the stuff that the applicant chooses not to say today for his own benefit? Oh no, this is dirty. This is how it is in Walton County, and I want you to see. And the Treasonous Trio, even at the beginning of it, Tony agrees. Donna steps in there and says, I don't agree with this. They should have to hear it. Everybody's here. Y'all found out today. Curry proceeds to tear him a new ass over this issue. I mean, just excuse me on my phone. Thought I silenced it. Curry hands Shipman and the planning department and everybody else and proves why we need a forensic audit. He proves it today. Curry absolutely is a laser with the questions that Shipman can't answer. And then Shipman wants to talk about Shipman even says, I've got to go behind my aide. Well, his aide was fired from the county for bad planning, and we continue to take her as Shipman's expert. Well, here Shipman says Melissa Ward screwed it up again. He just says it. He even says the county people didn't do it right, and that technical review missed this, and planners missed this, and that the public found it. The email was dated today. Stephen Schoen disagrees with Shipman. The applicant, even on his continuation date, one of the employees says the applicant asked for the wrong date. Well, too bad for the applicant. They should have heard it, and if the applicant did it wrong, the applicant should have suffered the fate of their own application that they were assisted with by the county. They've had every benefit, while the people who are worried about it around them have had all the onus put on them to try to show up and defend. And now they're here, and now they've already discussed the lawsuits against policy, and now they're just going to go continue it instead of doing the required and use the commission. And Brad, oh my God, Brad, you are not a lawyer. Brad starts discussing the legal posture and makes a court conclusion on his own that we can either decide here or we're going to have to, we'll speculate that we're just going to be back in court with the correct information. I'm not even going to replace his words. But clearly, Brad, Tony, and Danny realize that they have to shut up and color because Shipman and Clay are telling them to. I don't know. But Clay says the BCC could hear it. So the BCC had the right to hear it right there. And Curry and Johns wanted to do it, but the Treasonous Trio said, we're going to listen to Gary. Lawyers and developers are in charge of your county, and I hope that you listening to this segment will see that we must have change on the Walton County BCC. Because all this did, every continuance that this was a benefit towards the applicant and making it harder on the people who would be affected by the applicant's actions. So without any further, I'm going to finish this up because I'm Alan Osborne. You can't make this shit up. I'm going to explain the other two parts of the BCC meeting later on. Danny Glidewell. People, elections have consequences, and I'm going to put out a fact sheet on him. And Danny, I dare you to debate it with me. I dare you to say it's a lie. The only liar, Danny, will be you on the facts that I put out, and there won't be a damn thing you can do about it. You don't belong in leadership. You never lived where you did. You sold people out. There's millions and millions of uncollected things. You never said anything about all the sex scandals. You had the time card or your charge card issues. You fired Dee Dee over $500, but you ignored all the stuff in HR because HR was helping you get a free degree. I could go on, and I will. But for today, I'll let the BCC's actions as planning. And I hope all you affected people on this issue in South Walton tell all your voting friends that the BCC is not here to preserve a quality of life. The BCC is here to tax you to death and cater to people who put tourists who put money in the pocket of just a very few people at your quality of life expense. Look, I'll go into the beach issue later. Whoop, I spilled the beans. But until now, let's get on with the meeting.
Thank you. Good afternoon. Yes, today we did receive a request from the applicant to move this to the next available BCC meeting after this date for some additional time to draft and present a land use restriction, a land use restriction agreement on this site that deals specifically with the floodplain.
Is there any objection to continue, was the ask for a continuance?
That's correct.
Okay, is there any objection to the continuance?
Well, I think that we have a room full of people here that wanted to speak to this, and therefore I feel it's unfair to them to continue it.
And I agree.
Okay, as far as, if it's going to be continued, do we, I guess we can proceed with public testimony, public comment?
They'll get to do so, but understand they will not get to do it at the next hearing. That's the problem. If you let them speak at one public hearing, you don't let them get to come back at another. And I know everybody, historically, that has not been preferred, given that there's not going to be any presentation of the project, there's not going to be any opportunity for back and forth with staff or the applicant.
So I'm
But if
gonna
that's what the public wants, they can choose it.
I'm going to leave that up to the decision of those that are here for that particular project. Do you choose to exercise your right to speak today, or would you like to postpone it until the project actually comes up? So if you want to speak today, raise your hand. So we have one. If you would prefer to defer to the second half, how many would like to wait? So y'all want to, now, hold on, let me ask the attorney, is this as a collective or is this individually? So if they speak today, they're individually or not?
That's right.
But so it's not a collective.
Well,
If
they can't come back as part of a collective and try to stack the time. We wouldn't let them do that. There's no two bites at the apple.
But we don't have to approve the continuance.
You do not have to prove the continuance, but I would note that technically, if it's a continuance request, either they're going to speak on the continuance, which there's nothing to speak on, but continue it or not, or you wait for the full public hearing. But if we don't continue it and we want to have them speak on that, they're welcome to do so. But they don't get to speak at the public hearing twice. We don't allow two bites of the apple ever in these.
Well, the email is dated the 26th, which is today, for this change. And it just seems unfair to the community when they have taken time from their busy schedules to be here. And just because they want to submit a land use restriction agreement, that's not changing what they're trying to do. So
It's a great point.
If I could make a comment, and maybe Brooke Davis could come here too. She and I discussed this earlier, and under the LDC,
Madam Clerk, for the record, Gary Shipman.
yeah, Gary Shipman representing the Huffmans. The LDC, the way it's worded, if the property involves a floodplain, the way I read it, and Brooke agreed with me, we have to have the LURA approved with the land use change, meaning you have to review it and approve it as well. We don't have an agreed upon LURA, just like the public, I would think, they're going to comment on the application.
then why did we have it on the agenda if we weren't prepared?
Exactly.
Well, neither Brooke nor I were discussing it with the planners before now, but I believe that if it's heard without a LURA, if we won, they could appeal and it would be reversible. And if we lost, we could appeal, and it'd be reversible.
I'll be a little more pointed. The board can't approve it without a LURA, is the simple reality.
So why do we put all these time restraints in the process in order to be ready for D-Day? And then we get up here and a simple email can change it all. We can just send an email with 2 seconds left in the fourth quarter and we can go back to the beginning of the game.
That's why you get to vote, Commissioner. That's why y'all have the right to vote to approve or deny the continuance request.
Well, they shouldn't wait until the last minute to request this. They should have had it together if you were going to have it. You knew it was on the agenda.
Well, honestly, neither Brooke nor I had discussed the requirement of the LoRa. I mean, frankly.
Why?
It did
If it's
not-
necessary, why wasn't it discussed?
It was not, didn't come up in the review.
Mr. Curry, Brooke Davis on behalf of the county. To be clear, I think part of the problem is the wording of the comprehensive plan language that we're talking about today. Our floodplain manager had looked at this, and what her understanding was essentially she thought that this would work as it would have to be a condition for approval for the future land use map to be amended. So in my reading of it, as well as Mr. Shipman's, of what we read it today and discussed, it looks like it's actually functions as a condition precedent, that it has to be done for you guys to even consider having this future land use change.
And I'm not going to disagree with you whatsoever, but I keep hearing understanding, intent, hope, and thought we should have. All those, it's very disappointing. I mean, we come up here and we're supposed to be professional. We have all these people in the audience here. We're ready to go. And then 2 seconds left in the game, we want to throw an email and a speed bump saying, well, we can't go any further because we didn't have a Laurel. Are you kidding me? Are you kidding me? As much knowledge and experience as an attorney and as a county, we come with this to the podium. Really?
Honestly, neither Brooke nor I had discussed it.
I know,
today.
I heard that already. I heard that already.
So it states in this email that, as you pointed out in our call this morning.
Oh, go ahead, I just backed away.
So it states in this email that, as you pointed out in our call this morning, public comments have arisen regarding this issue. So it was the public comments that you've heard that had you thinking about this, because otherwise you wouldn't have known. Is that correct?
The interpretation from the planners was that it was, like I said, it was something that would have to be done more on the back end. So it would have been a condition that they would have to create a land use restriction agreement if it was approved. But what we're reading is that it has to be done for you to even consider approval. If you read the comp plan language, it is very clear, and so that's why the public comments were taken seriously by Mr. Shipman's office, and who contacted my office and said, hey, I think we have a problem. And I read through the comp plan policy this morning and I said, yeah, I agree. I think there is a problem. I think that the land use restriction agreement has to be in place in order for it to be considered by the commissioners.
So our own floodplain manager thought it could come in at the back end.
As a condition for approval, so that it would have to be done in order for development to be sought on the property. So it was a process concern of how it's written a little oddly, because it says in there, it says the developer to enter into. So it doesn't really read that it has to be done ahead of time. But I think in application, it's my opinion that it does have to be done ahead of time.
And it's-
Can we get a third attorney opinion?
I don't think you can approve it without it. Now, does that mean you're required to deny it? If you hear it today, I think you have to deny it because you don't have a LURA. That's my opinion.
But since we told you we're doing a LURA, I think if you deny it, I can appeal it because we've asked you to continue it. And I don't think,
I would note this about his request for continuance. If the board votes to deny it and the matter is appealed, the court's going to ask what the prejudice was to anyone involved in us choosing in our capacity as a legislative body to not hear this today. So if we choose to deny the continuance, we need to put that on the record. Ultimately, the court may well, without saying you had to approve it or not, simply send it back, like most remands occur in these cases, and tell us to have the hearing with the lawyer. So I would venture to say we're probably going to hear it at some point in the future with the lawyer, whether you deny the continuance and they reapply, whether you continue it, whether you deny it and they sue us. We are going to hear this with a lawyer at some point in the future, or we will never hear this. So we're going to have to hear it with the lawyer, is my position.
and honestly, my office, I'll take a little bit of blame. I had a talk with our planner, Melissa, this morning. And I told her, anytime we have a project where there's any flood zone or floodplain issue on the property, we have to do a LURA as part of our submittal. And it's funny, when I talked to Brooke's telling me the same thing, so she and I had the same thought. It's just apparently, we let the planners look at things without us, and I shouldn't have. But you have to have a LURA if there is any flood issue on the property. And the reason
For you to
for
approve it.
Right, because you have to approve the LURA. We can't tell you, oh, well, we'll do a LURA after you approve the zoning
Okay.
change, because the zoning change
I'd
is already
like to ask you
approved.
another question. It states in here that you wanted to move it to the 6th of June, but then on the next page, it says you want to move it to the 30th of June. So which do we want to do?
I thought we were going to move it to the next meeting, because it won't take that long to draft a LURA.
It will be
but-
the 9th of June. No, there is no 6th of June. No matter
Yeah,
what.
I thought it was the 9th of June, but
Well, it says 6th on this meeting and on this email.
The 6th was the incorrect date that was stated by the applicant. The correct date is actually June 9th, but because the advertisement date has passed, it would have to be to June 30th.
And that puts it in the south end.
Okay,
Oh,
Chair,
so it
I
has
have
to
one
be
more question.
re-advertised, is that it?
Yes.
According to our planning director, because it's continued to a date certain, I don't believe it would need to be.
I know we are going to
re-advertised.
re-advertise it because there's not a LURA noticed as part of the advertisement. So we do
Got it.
have to
Okay.
comply with the case law.
I think the LURA would have to be.
So that would be the 30th then.
It
Correct.
has to be, and it needs to be in the south end.
Chair, I
Okay.
do have one more question.
Go ahead.
How many, well, maybe this is going to show my naiveness here, but how many boards did this go through that this didn't come up? Did it go through planning
Yes,
and it didn't come up?
didn't come up.
Did it go through technical review at all?
So it does go.
Did it have to?
Steve shaking his head no.
No? So it went through just one board?
If I may, Mr. Curry. So it does go through a technical review by staff. It also goes through the Planning Commission, and it also comes here to the Board of County Commissioners. There were meeting minutes that were added from Planning Commission regarding the disagreement. It was a vote of 4-3. So that was brought to this meeting, given that conversation, that I felt that it would be important to add. I do want to also add to the record that our floodplain administrator did provide comments regarding specific sections in the Land Development Code that speak to development in floodplain areas. Some of that language is consistent with what we're seeing in terms of the LURA in the comprehensive plan. So there have been opportunities for the applicant to view that information, which we all have equal access to.
Okay, so we didn't bring this up during the planning phase of this at all. None of this came to mind, which we could have if we found out then. We would have still been in the first quarter of the game. Instead, we're here now. But so just to reassure, we went through at least two processes that didn't find this. And vetted extensively from what you just said. And we didn't find this and bring this to the attention at that time, correct?
Well, I do rely heavily on my floodplain administrator's comments. That was not something that was discussed
So that's a no.
earlier in the stages of this process. So,
And the
yeah.
planning commission, neither us nor
Oh, sorry, go ahead, Mr. Shipman.
but having it then brought to me today, it was our opinion, because you have to have a LURA with the amendment that you vote on, that we couldn't go forward at this point.
And to add to that, and maybe Stephen and Brooke can speak to this a little bit better than I can, but it's my understanding that historically, this commission has, I guess, my understanding is that land use restriction agreements are discouraged because it's a type of contract zoning. Correct me if I'm wrong in terms of my interpretation of that. No? Okay. So that possibly could have been a reason why it was not brought to the attention of the reviewers at the beginning.
I'm just
So,
struggling
at
with.
least moving forward, we'll be clear
Well, I'm just
in
struggling
terms of
that,
this
that
requirement.
you're asking for this board's decision on something today prior to the last minute email. Isn't it the process to have all of this ready and presented, ready for us to vote on? And it seems like we didn't. We failed yet again on a process issue.
I'd like to add too to that, if I may, that in the email, it makes it sound as though the only reason that we're where we are now is because public comments have arisen regarding the issue. So public comments is what got you thinking about it and realizing, so it kind of looks like,
The public's running the show.
well, the public.
If they weren't here, we wouldn't know
If
about
they
it.
weren't worried about the floodplain issues, if they weren't worried about it, it wouldn't be a comment. So now that we know they're worried about it, now we realize we've got to have this other piece to it.
Thank you, public.
So, what's the fairest way to do this? To accept that there were last-minute things that were discovered that lawfully prevents the applicant from presenting this to us today, and then we go forward subject to an appeal? Or do we grant the continuance and offer a fair hearing where everybody gets to speak, present evidence, and voice their concerns? If we go that route, then we'll do that on June the 30th. Is that amenable to everyone?
I make a motion that we continue this to June 30th.
A second.
Okay, so we have a motion by Commissioner Glidewell to continue the tab 35 to June 30, and seconded by Commissioner Anderson. Are there any questions at the board or comments?
I'd like to add one more comment. That this email goes on to say, we want to ensure our client's intent is for smart development. So that's in the email from your office, Mr. Shipman, that they want to make sure that that your client's intent is for smart development.
I don't know what Melissa sent you in an email. Frankly, I haven't read it. I can tell you what my intent was when I heard about it, which is on a zoning change, just like a development order, we can't go forward without the LURA because you have to approve the LURA. That's what's my reaction.
It just doesn't look good.
Well, I agree it doesn't look good, and I'm not too happy about it. And I can tell you my office will never have that happen again, or I doubt it after they heard me talk about it. And I got a feeling that Brooke is going to be saying the same thing in the planning department. If there is a flood zone area on a piece of property, whether it's a zoning or it's a development order, you got to have a LURA to address it. And y'all have to approve the LURA. So without the LURA, you can't approve it. And so I don't, you're right, it never should have even gotten here without a LURA. And I'll take part of the blame because I never should have allowed it. But I didn't pay attention to what Melissa was doing. And I don't think she thoroughly read, because the planners aren't qualified to interpret what these things are. But it's a condition preceding. And I'm sure Clay will chime in on that if you have questions. But condition preceding means it's just like in court in a lawsuit, like on a construction claim where they require us to go through a 558 pre-suit notice. We don't get to file a lawsuit until we do it. We should have filed it with the thing in the first place, but we didn't. So now we know.
And whatever's left over in terms of blame, I will take that. I don't
Stephen,
read this.
we're not trying to blame.
No.
Place blame.
But I'm going to explain here that I don't read that policy the same way that these attorneys do. I'm not a legal expert by any means. I read that policy is to say the board may approve it if the applicant agrees to do this. But that's again, a mistake on my part. So
Very interesting.
That's I think where some of this confusion landed. Certainly it took some of the public to wave some flags and say, hey, so that's why we're here currently.
Well, my biggest issue with the whole thing is, I mean, I understand what you're saying, but that the people took the time out of their day to be here.
Understood.
And that's an effort, you know, because there's a million other things people can be doing. And it's unfortunate because they thought they would make some progress here today. And now it's going to be pushed down the road to the end of June.
Yes.
So,
I think it's just another one of those things of, yet again, we find that there's actually some bad wording in an area that needs to be cleaned up, because this was not something that our floodplain manager and Stephen saw as an issue that needed to have legal input and legal interpretation. It looks to read, very clearly of, it just has to be done at some point. It doesn't read in and of itself that there's any confusion or any need for a legal interpretation. So that's why when we were presented with it today, legal opinions read it differently for the application of that actual comprehensive plan language, rather than just reading it word for word. Because sometimes there's difference in how it reads versus how it works in application. And I think that's where it changed the game quite a bit.
Well, just to be clear, we went through two processes, a planning board, TRC, application, everything else, two experienced, well-knowledged attorneys, and a public comment is what caught it.
It was
And
not
I just,
done.
well, wait, and I just want to be clear also on this, that if you notice some of the legislators that are bringing some of these bills down, they're trying to take public input and public hearings out of the mix. So this is what you're going to get when you do that. I'm just going to tell you right now, and that's on the record.
What it also shows, because there was no public comment about that particular issue of the planning commission, but what it showed me, and I'll take blame, I need to go behind my planner, and I guess Brooke has to go behind her planner to make sure that they are, because planners aren't trained to read the law. And this is a legal interpretation, which we've talked about a lot over the last couple of years, about what the law requires of all this stuff. You can't approve something conditioned on us actually writing it, but you may not like what we write.
Okay,
Stephen?
so the question that's before us that has to be disposed of is where we are on the legal posture. So it's been presented that without the lure, we're not standing on concrete ground in legal posture. If we did it without the lure, we would be making the presentation standing on sand as far as being in legal posture. So it's a matter, so the question before the board is, how do we proceed? Do we take a time out and address it on concrete ground?
Okay.
Or do we
Now
go
I'm gonna skip
ahead
through a lot of
and
that. There
address
are
it
comments
today
from
with
time.
uncertainty?
The only thing that matters.
So we have to make that decision. So we've got a
Because they
motion and a
messed this
second. Is there
up.
anyone from the public that wishes to speak on the
The only thing that really
continuance?
matters is the final vote.
On-
All right, we're
on
gonna
the-
pick
on
it
the
back
matter of
up here. So you've heard all the arguments, and you just saw Brad just completely steered, and Tony backed off what he said. It needed to be heard, but because it's Shipman and because it's the right people, and look at Brian Kellenberger's face of how incompetent his staff full of people and lawyers are. And you know why, Brian? Because y'all have never held them accountable. Thank you, Dan Curry, for doing your thing. Donna did the right thing. Could have been stronger. Danny was his usual. The look on Danny's face tells you everything. And Tony and the Treasonous Trio there. See, Brad, ever since Brad had to make the alliance not to let Dan Curry be the chairman, even though he had been the vice, Brad and Tony and Danny have all had to vote lockstep because I'm sure the, wink wink agreement they had to take Brad right to the chair for election year. You can't make this shit up, but watch their final vote.
Okay, shows motion passes.
Commissioner Johns and Curry.
And just like that, even your local government
Anyone
has
else?
sold out to the PACs
All in
of
favor of the motion
developers
to continue,
and
say aye.
lawyers.
Aye. All opposed,
Like I
nay.
said on that
Nay.
one show, when I was a small
The
child,
item
people played
continued 4 to
cops
1
and
with
robbers.
Commissioner Curry in the
And
dissent.
now
3 to
it's
2.
cops and
Okay,
lawyers versus the
Shows the
public.
motion
You can't make this
passes
shit up, but
3
you
to
can
2
unelect
with
it.
Commissioners Johns
No
and
incumbents in
Curry
the
in the
next
dissent.
race. Vote informed. I'm Alan Osborne. Till next time, y'all keep them straight, because they can't keep themselves straight. You hear?